Hey folks, welcome back for another week of news in law and ethics. Sorry, I've been away a little while. I've just got a few students, like 600 of them, that I've been getting set up for the fall semester. So anyways, I'm glad to see you back. One of my students in the honors section of Intro to Law, what's up Dominic, thank you, shout out for sending this article, sent me this excellent article about California Bill number 5, and this is a new piece of legislation that codifies some decisions made by the California Supreme Court. That's a long way of saying this is something that is a legal and regulatory new area that might blow up Uber in California. So I've been using Uber in my classes for a long time as an example of a company that probably misclassifies its employees. Okay, so we talk about in business in the U.S., there are usually two kinds of workers. There are independent contractors, and then there are employees. Okay, and then there's kind of this shadowy third category, which is companies that have people that are properly classed as employees, but they try to treat them like independent contractors. And Uber and Lyft and a lot of other companies have been doing this, and in fact it's built into Uber's business model. So why does it matter whether somebody is an employee or an independent contractor? Well, there's a lot of reasons. Number one, it costs more to employ a acknowledged W-2 employee. You have certain benefits you have to pay them, you have to do tax withholding, you have to pay into Social Security and Medicare, and also they have important labor protections like minimum wage and overtime laws. California, interestingly, also has or had a rule that if you drive on company time for company purposes, you have to be reimbursed for your mileage and your gas. Obviously, that would turn the financial model of Uber on its head, and so they've been in litigation for years and years and years over this out there, and California Supreme Court has found against them, and also now the California legislature has said, look, app-based gig work, where the people meet the right of control tests, those folks are employees, okay? So gets us to our next point. How do you tell whether someone is an employee or an independent contractor? I get a lot of folks who say something like, hey, I need you to write up an independent contractor agreement. It's going to be for this person. It's going to be 40 hours a week, and they're going to be here from 9 to 6 with a 1 hour lunch break, and we're going to pay them this salary, and such and such, and we'll have some money for training and continuing ed expenses and things like that. So I'll say, hey, I can write up absolutely anything you want, but you realize that the court may look at this later and say that you've exerted so much control over this person that they are a de facto employee. Okay, so you can write whatever you want on the contract, but the more control you exert over the means and methods of their work instead of taking a hands-off approach, the more likely they are to be classified as a de facto employee. And normally when the time when you find that out is when you let somebody go that you had classified as an independent contractor, and then they make a claim for unemployment benefits. And then it goes to an administrative law judge, and they get to decide, okay, is this person truly an independent contractor who's entitled to no benefits, or is this person actually a de facto employee? Another reason this matters is because of liability to your company. All right, so here's a picture of a gentleman who is being driven by an Uber driver in Chicago. He had an argument with the Uber driver. I believe it was over politics. What else? Of course. And the Uber driver turned around and hit him in the head with a hammer. Right? That's terrible. But it also brings up an interesting legal question. So if you're this fella, who do you want to sue? Do you want to go after the person who drives around in their Prius in their spare time and settles arguments with a hammer? Do you think that person has a lot of money sitting around to satisfy a judgment? Do they even have insurance? Possibly not. You want to sue Uber, the billion-dollar corporation. Now, Uber says, no, our drivers are independent contractors. We don't have any control over them, so there is no respondent superior liability. If our drivers do something to harm you, that's just on them, and whatever insurance they may have, that's not on us. All right, this gentleman has been in litigation now for years seeking to establish that, look, no, Uber drivers are an agent of Uber, and under any reasonable kind of means of control test, Uber should have to answer for their actions. If you look at it, Uber provides training, they do screening, they have certain requirements for the vehicle and the person. In my mind, that starts to look a lot more like an employee than an independent contractor. So we'll see how this case turns out. Again, this is not in California. It's not going to be directly affected by this new law, but I think it's pretty interesting. Uber, unfortunately, and Lyft both have had recent incidents with drivers sexually assaulting passengers as well. And so I think as you continue to see these kinds of cases, the question of are Uber drivers employees or independent contractors across the U.S., that's going to be very, very salient. So I'll put a link to the article down in the video notes here, and then I also put a link to the bill track. All right, some pretty interesting things going on in California. This could shake up a lot of things. We'll see you guys.